Okay, everyone, good evening. So tonight we're going to be covering the topic on taxation, appropriation, and spending. Now, before we start talking about this week's topic, would any of you happen to have any questions or comments? None? So we could probably proceed. Karen, raise your hand. Okay, Karen. Are you going to have to turn on your mic?
Yep. I think I just did.
Okay, yes, I could hear you.
I had a question from the textbook. Do you have it handy?
I do. Yes.
Page 352.
Hang on. Okay.
The first paragraph there, towards the end of it, it says that public service salaries and administrative expenses.
Hang on, I haven't found it yet. Which one is it?
Page 352.
Yes, and which one?
Towards the end of that first paragraph,
Okay.
public service salaries and administrative expenses in appropriation bills 1 and 3, which are unamendable, and amendable items in bills 2 and 4.
Hang on, I can't. Okay. So the third sentence towards the end.
Yeah.
Okay, can you read that for me again? So I kind of failed to see that.
Appropriation bills 1 and 3, which are unamendable, and amendable items in bills 2 and 4.
Okay.
Okay. And then if you read the start of the very next paragraph, it says bills 1 and 2 are not amendable.
Okay.
And I'm just confused now because it says that bills in items, the previous paragraph says that bills 2 are amendable.
I'm going to have to get back to you on that because I haven't really noticed it.
Yeah, I tried to research it, but I'm afraid the parliamentary website wasn't very helpful.
Okay. Thanks for taking that up, but I'm going to have to go over it because I'm not exactly sure what the authors may have meant.
Okay. Thank you.
I'll get back to you. Okay. Any other questions? None? Okay. So we could begin. So as we know, taxation is important because some would say that taxes are the lifeblood of any society. So you can't have any society without any taxes. And so you can just therefore imagine that from the viewpoint of the states, where, as we will know later on, or as you've probably read, they're no longer permitted to impose income taxes. What it means is that to a great extent, the states can be at the mercy of the federal government. And some of you may have noticed, if you had gone through the textbook and the lecture notes as well, it wasn't always historically so, mainly because there is nothing in the Constitution actually which prevents the states from passing their own taxes. So as we said, the states can pass any legislation, including income taxes. They could pass laws pertaining to income taxes or taxes in general, except for excess taxes, which are prohibited, for example, by the Constitution. But because even if the federal parliament may be given the power to legislate on a subject under Section 51, unless the constitutional provision particularly speaks of an exclusive power on the part of the federal parliament, then the power of the state parliaments to legislate on the same subject coexist, except to the extent that the federal parliament may decide to actually control that entire field. Then in that case, the state parliaments would be would no longer be permitted to actually legislate on the same subject where there is an inconsistency. But in relation to taxes in general, there's nothing in the Constitution except for excess taxes, which would have prevented the states to pass laws on concerning taxation, especially income taxes, except that, as we know, historically, the states gave the power to the federal parliament to control income taxes. Now, having said that, as I said, it's crucial that we talk about taxation because of its importance to any government. Because as we said, no government can exist without taxes. And in the case of Australia, therefore, because the power to tax has now been, the power to impose income taxes has now been monopolized by the federal government. To an extent, therefore, there might be what is known as a fiscal imbalance and gives the federal government a power to, in a sense, control what happens in the states by tying up the way that they would distribute the revenues from income taxes to the states. And so what therefore has happened, as you will notice, is that there have been attempts on the part of the states actually to try to be creative and find means by which they could actually raise revenues without those revenues being considered either as income taxes or those revenues being considered as excise or taxes on goods. And so the struggle continues between the states and the federal parliament. So, hang on. Yep, okay, it's being recorded. So having said that, tonight, after studying this topic, you should be able to discuss and explain what constitutes a tax, discuss and explain what is an excise, and discuss and explain the power of states to validly pass taxes and license fees. So we will begin by taking up the first discussion question. Can I ask somebody to read the discussion question for us? Volunteers? Any volunteer to read the discussion question?
I'll read the discussion question, Manjo.
Sarah. Okay.
It's Sarah.
Yep. Go ahead, please.
I haven't got my glasses on, so bear with me. The Commonwealth Parliament passed the Business Liability Insurance Act, Commonwealth, requiring certain types of business to get mandatory business liability insurance. It also required insurance companies that wish to engage in the business of providing businesses liability insurance, to secure a license and pay a license fee based on 2% of their projected sales revenues for each fiscal year. Is that how you say that word? I don't know. License fee adjustments are to be made 3 months after the end of each fiscal year. I've never seen that word before, sorry. XYZ Insurance Limited seeks to challenge the law. On what ground can a challenge be made? Advise the company on whether its legal challenge is likely to prosper.
Thank you, Sarah. Okay. Any volunteers who would like to go? Who would like to make a go at the tutorial question? Volunteers?
Okay, hi Manjo. I guess I'll have a go. Actually, I found this chapter very, very confusing. I don't think it was till the end of the chapter that I realized that excise was also a tax or something like that. I thought excise was excise and tax was tax. Anyway, I found my answers to all the questions seem to be remarkably similar, so I was just going to keep quiet first. But anyway, I'm happy to expose my ignorance. Firstly, the issues here. Well, the issue here is the act imposing a tax? Is this license fee actually a license fee, or is it a tax? Just because it says it's a license fee doesn't mean it is a license fee. So, so if it is a tax, then is this imposition of the tax valid? Firstly, of course, you define what is a tax. It's compulsory by public authority for public purposes, according to Matthew. So now we have to consider the substantial items within. So I found that actually I had to go through each case and actually find out the details of what is in the act that they are arguing about in order to try and understand their reasoning. Firstly, there's no choice but to pay Air Caledonian. The fee is imposed by a public authority and it's paid to the government. No issue there. Then the question here is, if although the fee is based on a projected sale, which is later adjusted, does it make it so connected to the item in there, which is insurance, that makes it a tax, or is it just an amount of money that is appropriated in order to run the regulating authority? So that the differentiate between a license and a tax. So if it is just for running the authority, recovering costs, then it shouldn't be an excessive amount. So if you say that the amount you have to pay is 100% of your revenue, of what the cost, like tobacco taxes, then it is not a license fee. It's actually a tax. So anyway, after all that, I'm still not very sure what's the answer. I just said that I think it's a tax, and under Section 55, it should not be tacked onto a regulatory scheme. So if it turns out that the court agrees that it is a tax, then it will be invalid. But if they decide it is not a tax, then it would be valid.
Okay, so tell us more about Section 55, BKF.
Section 55, I think there are three parts of Section 55. It just basically says that if you want to impose a tax, that bill cannot include any other item. It can only be about taxes.
Very good. And so in this case, you characterize the license fee to be actually a tax, given the way that the tax has been defined by the case of Matthew versus Shukri Board. Very good. And because it is a tax, and in this particular legislation, it also talks about regulating business liability insurance, then in fact, there are two subjects in the law, which therefore contravenes Section 55 of the Australian Commonwealth Constitution, which prohibits the tacking of a tax matter on another piece of legislation. Very good. So that's the correct answer here. As very well explained by BKF, this law is unconstitutional because in the same law, it imposes a tax and at the same time seeks to regulate the business of business liability insurance. So in the same law are two subjects. One is taxation. The other one is business liability insurance. And because the so-called license fee is in fact a tax because it meets the definition of what a tax is according to the case of Matthew versus Shukri Board, meaning it's a compulsory exaction of a certain amount of money for a public purpose by a government body, then therefore it is a tax. So because this is a tax which has been tacked into the same law, which does not speak of a tax, it therefore contravenes Section 55 of the Australian Commonwealth Constitution. Clear enough? Any questions there? Okay, now let's change the facts a bit. Just looking at this specific question, we're just going to change the facts a bit. Okay. Now let's assume that using the same facts, let's assume that what it does is to impose a license fee amounting to, let's say, $10,000 per year. So it imposes a so-called license fee of $10,000 a year on insurance companies. So instead of the so-called license fee being based on 2% of the projected sales revenue for each fiscal year, let's assume this time that the license fee is an amount equal to $10,000 each year. What would you then say about the constitutionality of that law? So I've changed the question a bit, changed the facts a bit. So instead of the so-called license fee being based on 2% of the projected sales revenue, it is now based on a flat fee of $10,000 a year. Volunteers?
Manjo, would you say that that leads towards like some of the thinking in the capital duplicators, the porno case, where they were looking at it as being a regulatory scheme because it's not linked to sales or anything like that, and it's a fixed fee, that it's not generating revenue, and that would lead to it being a regulatory payment to implement the scheme.
Okay, and if that is the case, what then?
Well, then it would meet the test of being a license fee, and it would pass, and it could be imposed under the Act.
Because it isn't a tax.
That's right.
Very good. So if it isn't a tax, it clearly passes the test as a license fee because the cost of the license fee is commensurate to the cost of providing the services under the regulatory scheme, then it won't be a tax. Very good. So because it won't be a tax, then it's permissible for the Commonwealth Parliament, obviously, to pass a legislation which talks about business licensing and at the same time impose a license fee. Very good. Okay. Moving on. So thank you, Nicholas. Discussion question 42. Volunteer. Can I ask somebody to read the question for me? Okay, let me read it then. So in order to control and regulate the importation and exportation of dietary supplements, many of which had exaggerated claims and no proven efficacy, the Commonwealth Parliament passed the Dietary Supplements Regulatory Act, Commonwealth. Under the Act, businesses, regardless of size or annual revenues, that engage in the importation, sale, or distribution of dietary supplements, as defined in the Act, are required to pay a license fee of $5,000 per year. XYZ Enterprises, a small company engaged in the sale of dietary supplements solely in Victoria and with annual sales of $100,000, seeks to challenge the Commonwealth legislation. On what grounds can a challenge be made? Advise the company on whether its legal challenge is likely to fail. Volunteers. Volunteers? Come on. This, it's just a class, so we're free to make mistakes here. Just give it a go. Remember, you're trying to become lawyers, and when you do become lawyers, you must get used to the habit of articulating your thoughts, making arguments, persuading a judge to rule in your favor. And so this is a perfect opportunity for you to practice your skills as an advocate, practice your skills as your skills in oral advocacy. So can we have a volunteer there to respond to question 42? I kind of saw somebody raising his or her hand, but it disappeared. Who was that? Okay, Karen. Yes.
Okay, well, first of all, is it a license fee? Is it a tax? And if you look at the capital duplicators case, it held that to be a license fee, the amount paid, the exaction must be part of a regulatory scheme and not a revenue raising thing, and involve the imposition of a justifiable amount commensurate to the cost of implementing the scheme. So in this case, it's talking about controlling and regulating the importation. It doesn't specifically say, but I suppose the implication is that it's then going to do something about these exaggerated claims and efficacy. So obviously money needs to be involved in that. The question is the size of the fee disproportionate to people's income in relation to what they're getting off it? I think I've about run out on that one.
Okay, hang on there. I've got a question for you. You did say that you did make a statement that the question really is whether or not the cost of the regulation is proportionate to people's income. Is that a relevant issue? The question of whether or not those against whom a license fee is assessed could actually afford it. Is that the question? So that if, for example, in this case, it's too expensive and excessive in relation to XYZ enterprises, that is a ground to question the constitutionality of that law, because then it amounts to a tax instead of a license fee. Was that the kind of thing?
But $5,000 a year is 5% of their annual sales. So I'm not sure if that would be considered disproportionate or not. Obviously, it's not as much as there would be in the tobacco case, where it was talking, I think, 75% or something like that. So perhaps 5% is considered reasonable.
Okay, but the question for me was that the alleged cost of regulating the license, of regulating the regulatory scheme. So in other words, the cost of the license, is that measured in relation to the ability of a business to pay, or is it based on something else? How does one know that the amount or the cost of the license fee is something that would then can be argued to actually be a license fee? Is it based on? Yes.
The information provided says that it's a flat fee regardless of the size or annual revenue of the business.
Yes.
Yes. So obviously it says that XYZ is a small company. Obviously a bigger company, it would be much less of a percentage of their income.
Okay. So let's just pursue that a bit, and Karen could continue, or somebody else. But let's assume that XYZ Enterprises only earns about $50,000 a year, and the cost of the license fee is $5,000. Does that make a difference to your answer?
I think what you're trying to get at is what sort of service does XYZ benefit from this regulatory authority? Isn't it like home bush power mills or something like that? If it bears no relation or is way excessive beyond what sort of services that are provided by this regulatory authority, then
that's right. That's part of the question.
A tax. It's actually a tax and not a license fee, and therefore it would be unconstitutional.
Okay, but that's actually part of the question. But my question really is, do you look at it from the viewpoint of individual, potentially taxpayers or businesses, or do you look at it from the aggregate, meaning from the industry? So in other words, there might be some which will find it excessive. There might be others which will find it to be very inexpensive. So it's not a question of its effect on the business itself, but it's really the question of the amount of so-called license fee being assessed and the cost of either running it or the potential benefit to businesses in general. So in other words, if in the case of, let's say, XYZ Enterprises, it is too excessive, meaning XYZ Enterprises could hardly be in a position to pay for it because it's expensive for such a small company, would that invalidate the law for then becoming a tax instead of becoming a license fee? In other words, does the character of the imposition of the compulsory exaction change on the basis of how it affects the business?
Can I jump in? I think the effect has to be disregarded. I think part of the idea of a license fee is to restrict the number of people that conduct a business or something like that. And I'm just thinking about, say, owning a car in Singapore or something like that. You know, not everyone can do it, and it's restricted for a reason that is there as part of the regulatory scheme to stop there being hundreds of thousands of supplement salespeople, and their sales turnover is their problem, not the government's problem.
So that's good. So that's a correct way of putting it, according to Nicholas. It shouldn't be measured. The character of the imposition shouldn't have to change as a result of its alleged impact on a business. So that's not really material. That's not really relevant. So it's possible that the effect of a license fee, the amount of the license fee, is disproportionately excessive on a business. That shouldn't change the character of a compulsory exaction as a license fee, if in fact it is a license fee, because its main purpose is as a regulatory measure and not as a revenue generating activity. Okay, now the question though is, so I heard it from Bikyat, was it? So I'm getting confused now, where the argument was made that this is actually in the form of, that this is in fact a tax, because it seems to be excessive to the cost of implementing the scheme. Somebody said that. Might have been Bikia. Now the question I have is, can somebody make an argument to say that this is not a tax? Is there anyone among you who would like to argue that this in fact is not a tax but a license fee? Volunteers? Comments? Volunteers? So everybody agrees that this is a tax, because $5,000 is excessive for the purpose of running the regulatory scheme. Is that it?
Would it be?
Hold on.
Karen.
Hang on. Sorry, Karen. Before you go do that, was there anybody else I heard wanting to say something apart from Karen so far? Was there anyone else?
Yeah, I want to give it a go. I think what Nicholas said was impaired to what you're asking, that if it is to regulate the industry, so it's not infiltrated with everyone doing the business of dietary supplements, then it is a fee. It doesn't matter in regard of the size of the business. Like if you're in the sport exercise industry, it doesn't matter if your industry is with 100 members or you have 20,000 members. If there is a regulatory fee, you have to pay it. So I think this question is a fee because it's just a set amount across the board of people dealing with dietary supplements.
Okay. Now the question I have therefore is, if the amount, the compulsory exaction is applied to everyone across the board, does it then mean that it is a license fee? Because a tax is in fact applied across the board. It's often applied across the board. In this case, this is so in other words, it's not ad valorem, it is a fixed fee. But as argued by BCAT, I think earlier, the fact that alone that it's not ad valorem, meaning it's not according to the amount of sales revenue, but it is a fixed fee, does not mean that it necessarily is not a tax. It can still be a tax if it is excessive. So the question I have is, can an argument be made that $5,000 is not in fact excessive in terms of the cost of running the regulatory scheme? So that's the question I have. Can an argument be made that $5,000 is in fact reasonable, proportionate, and commensurate to the cost of operating the regulatory scheme?
I think it depends on which side of the business you are. If your business is bringing in $1 million income, the fee will be irrelevant. It will just be part of it. But I think because we're looking at this XYZ enterprise because it's a small business and the income is like the fee is not proportionate to the income for that business. That's why we're thinking probably is a tax. But looking at it, according to Section 55, these things got the fee is for sale and distribution of dietary supplements, which doesn't have anything to do with tax, in my opinion. It looks like fees. I've run out.
Thank you. So thank you, Oluwayumi, for that attempt. Now, B actually is making a point here in the chat box that it would depend if the amount is excessive in relation to the services provided in running the regulatory scheme. So in other words, you could actually make an argument that this is not excessive. How are you to know that $5,000 is excessive to run the scheme? If it requires a constant surveillance, if it requires a constant monitoring of businesses, including probably doing tests, laboratory examinations to determine if they're actually efficacious, to look at marketing claims, so that entails costs. If the amount of if the costs involved, therefore, in running the regulatory scheme amounts to millions of dollars because you have to hire, technical staff, scientists, and so on, and there are not that many in the industry. So obviously, the moment you spread out the cost across businesses, regardless of their size, then it has been calculated that the cost of running it has to be $5,000 per year per business as multiplied by the number of businesses. If you argue it that way, then you can make a justification that this is in fact a license fee. So I point that out because we shouldn't just simplistically say that it is excessive. What is excessive really, to a great extent, can be a question of fact. In other words, this question is a matter of proof because the cost, the determination of whether the cost of running a regulatory scheme is excessive or not ultimately depends on the actual cost of running it. So $5,000, in fact, may be the reasonable or the actual cost of implementing the scheme. So again, that in the end will depend on the kind of argument you are able to make. So was that clear enough? So don't say straight away that it is excessive, therefore it is a tax. Why do you say it is excessive? You need to be able to explain that. So in other words, you're making an assumption. On the one hand, you're making an assumption that $5,000 is too much because in your calculation, there are so many of them and how much will it cost to run the scheme? So perhaps in that case, you can argue that it is excessive. But if on the other hand, you're arguing that there are not that many and the costs of running this scheme would actually be low, then you can make an argument that it then becomes excessive and therefore is a tax. Okay, clear enough? Now, let's just change the facts a bit, okay? So we're going to change the facts a bit. Now let's assume that this is in fact a tax law. So it becomes a tax on dietary supplements, actually as a way of regulating the industry. Or in fact, not just a way of regulating the industry, but in fact of discouraging the industry. So let me repeat. The purpose of, so we're changing the facts, just for us to know, okay? We're changing the facts a bit. So this time, the purpose of the legislation is clearly to regulate the industry and to discourage that specific industry. And so therefore a law was passed, and it says that this time a tax is imposed. So clearly they're saying it's a tax. It's a new legislation. It's no longer Dietary Supplements Regulatory Act. It's simply an amendment, for example, of the income tax of Australia. But what it does say there is that a tax of, say, 75%, or maybe even 80%, is imposed on all businesses that engage in the production or sale of dietary supplements as defined in the Act. Okay? So it's purely a tax law. We know that the purpose of the legislation is to regulate the industry, in fact, to discourage certain businesses from operating in the industry. It doesn't say it's for regulation. We know it's for regulation though, but this time a tax of 80% is imposed on the sale of any business. So a small business is seeking your legal advice to question the constitutionality of the law, not because there is a tacking, because there is not, it's just a tax law pure and simple, but he is claiming that the tax law is unreasonable, excessive, and confiscatory, and oppressive rather. So there is a claim by a small business that, you know, the tax law is running the business to the ground. So therefore, the tax law is unreasonable, excessive, oppressive, and confiscatory. If you were the lawyer, how would you advise that company that is complaining about the constitutionality of that new law under the new facts that I gave? Comments?
So I'd start following the HAR and New South Wales line of thinking and start to consider it more as an excise because it deals with goods and it's there to restrict sale of goods and that trade. And then because it's been couched as a tax law, challenge it under Section 55 because it's described as a tax. And the laws imposing duties of excise shall deal with duties of excise only. So that would therefore make it unconstitutional in a very rapid way.
So hang on. Are you saying, Nicholas, that the Parliament cannot pass a law on excise?
No, that's not what I'm saying, Manjo. So I'm saying they can pass a law on excise, but it needs to be solely a law on excise. So
okay, so that's good. So we're clear on that. Very good. So I made the point earlier that this is purely a tax law. So this is in fact a purely excise law. My question was, could an argument be made, could a claim be made that the law is unconstitutional because it is unreasonable, confiscatory, excessive, and oppressive? That was my question. Because it's running businesses to the ground. That's the point. And in the back of it is that it was actually an attempt to regulate the industry, in fact, to discourage businesses in that industry. Can the constitutionality of the law be questioned?
My gut is saying that no, but I'd have to do some further reading on it. I can't answer that.
Okay. Well, we actually have an answer here from B. nothing prevents the Commonwealth Parliament from passing confiscatory laws. It's within the power of the Commonwealth Parliament. If it decides to impose taxes amounting to 90% on any business, it would be constitutional, because that is for the Commonwealth Parliament to decide. And what would be the reason why the courts would be unlikely to intervene in such a matter as to whether or not 90% are excessive, confiscatory, and therefore contrary, for example, to a democracy and contrary to the ideals of capitalism in a free society? Could the courts make that argument? What do you think? What do you think? The answer is no. It becomes a political question. So what is excessive in that sense? In the sense that it becomes confiscatory, that is a political question that is best left to the elected members of society to decide, and courts will not intervene. And more importantly, there is no recognized constraint on the powers of the Commonwealth Parliament when it comes to passing tax laws. For as long as, that's right, so as Ken pointed out, courts should only rule on constitutionality, not questions of fairness or unfairness. So there is no recognized limitation on the power of the Commonwealth Parliament to legislate concerning taxes, for as long as the legislation is in fact purely a tax law. So it is up to the Commonwealth Parliament to decide the amount of taxes that it can impose. Okay.
And it would then be, sorry,
Robert.
it would then be similar. I know that the Fair Work legislation was to do with industrial relations, but it was changed with a change of government by the people, not a change of the legislation by the courts. And in this case, if the general public sufficiently felt that the 90% tax was unfair, the next election, they elect the opposition who says, we will repeal the tax.
So in that case, it's not so much a question of the constitutionality of the law. It is recognized that the law is valid, but at the end of the day, it's possible that the politicians may feel that it is up to the people to make it directly, to make a decision on that, either particularly through an election. But it's certainly not for the courts to decide, because that is a political question. Okay. Discussion question number 43. The Commonwealth Parliament passed the Overseas Education Providers Act, Commonwealth, to regulate the provision and delivery of education to overseas students by Australian education, by Australian educational institutions. The Act also requires such overseas education providers to contribute an amount equal to 2% of tuition fees paid by each overseas student to the Australian Education Advancement Board for its annual operations. The AEAB is a non-government organization created by and composed of overseas education providers to self-regulate the provision and delivery of education to overseas students by its members. North Star International College, a private education provider catering to overseas students, and which is not a member of AEAB, seeks to challenge the law, particularly saying that under the definition of Matthews versus Security Board, a definition of a tax is one which is a compulsory exaction of a fee for a public purpose by a public body. In this case, the AEAB is not a public body, it is a private body. So having said that, on what grounds can a challenge be made? And advise North Star International College on whether its legal challenge is likely to prosper. Okay, B says no. Comments? Volunteers?
Australian Tape Manufacturers Association Limited and Commonwealth rings a bell. And it may not have been a private group.
You're cutting out, Robert.
Sorry, I'm working on my laptop, not my desktop. It doesn't have the same power as my desktop. Australian Tape Manufacturers case, I think, dealt with public authority and whether a privately set up group could, if the Parliament set up the legislation to provide the level of taxation, it could then be any group could what am I looking for? The Commissioner of Taxation has a separate role to the actual legislation that allows the Commissioner of Taxation to tax individuals or businesses. So in this case, the Parliament has made the Overseas Education Providers Act, and the AEAB is simply the one that enforces what the Parliament has legislated.
But the point that the Northside International College was actually making was that under the definition of Matthews versus Chicory Board, the exaction, the collection is meant to be made by a public body. And it's arguing that the AEAB is not a public body, because obviously it is not. It is a private, non-government organization. So it's saying that because it is not a public body, this can't be a tax based on the definition of Matthews versus Chicory Board.
And I believe that Australian Tape Manufacturers refutes that.
Very good. So in the case of Australian Tape Manufacturers Association, as pointed out by B as well as by Robert, there is nothing which would make an exaction not a tax simply because it is being collected by a private agency. On the one hand, it can be considered that the fact that a private entity is being made to collect a tax, that private body then becomes a public body, a limited public body at least, in the context of collecting the taxes. So it's still a tax. And certainly, there is no requirement, notwithstanding Matthew versus Chicory Board, as pointed out by the Australian Tape Manufacturers Association versus Commonwealth case. There's nothing which would make a tax not be a tax simply because it is now being collected by a private body. That would still be a tax if it is in fact a compulsory exaction of a particular amount of money. Okay, so final question. Very good, thank you, Robert.
Sorry, excuse me, Manjo, sorry, but wouldn't the same problem occur again? This is an act to regulate the education, but now they've included a tax in it.
Yes.
Does that make it unconstitutional?
That's right, because it is a tax, and that tax is, so that's good, so we missed that part. Because this is a tax, and at the same time, it regulates the education industry, there is therefore a tacking of a tax provision in that law. And that is the legal basis to challenge the constitutionality of this law. Because it is in fact a tax law, and it has another subject which talks about the regulation of private education. So that's right. So the basis of the constitutionality of the law would be that it violates Section 55 of the Constitution, because the amount of 2% actually constitutes a tax. And in this particular law, it contains both a tax provision as well as a provision regulating the provision and delivery of education to overseas students. Therefore, it is constitutional for violating Section 55 of the Australian Constitution. Thank you, V, for pointing that out. Okay, as pointed by Karen, it is not essential to the concept of a tax that the exaction should be by public authority. So there is now a way by which the case of Australian Tape Manufacturers Association versus Commonwealth redefined the notion of the classic definition of a tax as defined in Matthews versus Chicory Board. Now, final question. The Queensland Parliament, so it's not the Queensland Parliament, so it's the state parliament this time. So the Queensland Parliament passed the Dietary Supplements Regulatory Act, Queensland, to regulate the sale, marketing, and distribution of dietary supplements in Queensland. Under the Act, Queensland businesses, regardless of size or annual revenues, that engage in the importation or distribution of dietary supplements, as defined in the Act, are required to pay a license fee equal to 0.5% of their annual sales, or $10,000, whichever is higher. XYZ Enterprises, a small company engaged in the sale of dietary supplements in Queensland and with annual sales of $100,000, seeks to challenge the Queensland legislation. On what ground or grounds can a challenge be made? Advise the company on whether its legal challenge is likely to prosper. Volunteers?
I might throw out that Dennis Hotels Proprietary Limited in Victoria would make this valid law because it escapes the definition of excise in a similar manner to what they now do with fuel station franchisees and what have you. If it doesn't fit the category of the federal domain of the excise duty, then yes, it would be legal.
So Robert, you're saying this is not an excise?
I don't believe so. It's a license fee. That could be up for discussion, I suppose, but it's not anywhere in the actual process of manufacturing, or it's an end of the line license fee tax as opposed to and along the manufacturing process duty.
I see. So you're focusing on that. Nuts. Okay. Comments from the others. Comments on the others, from the others.
I kind of agree in principle, seeing as I stake and impose tax on a service, and we're specifically looking at importing and distributing goods. So if you could turn it in such a way that you were looking at the act of importing or the act of distributing, I think there's a get out of jail for the states there.
How about the fact that, hang on, it is actually equal to 5% of the annual sales?
Is there a question of, like, it's not it is to regulate sale, marketing and distribution, so it is a regulatory scheme.
It is a regulatory scheme according to the Queensland Parliament. However, the fact is they're basing the license fee on 5% of the annual sales. Is that potentially legally impermissible? Brad, I see you putting 0.5%. So what does it mean?
Sorry, I was just correcting. It wasn't 5%.
0.5%. That's right.
Well, I guess it depends whether it's constituted as a levy or a tax.
Uh-huh.
So Because it's not. I wouldn't have thought it was a tax, as it's got an upper threshold or a minimum threshold. So it's more like a levy or an excise.
Okay. An excise is always a levy. A tax is always a levy. The question is it a tax or is it a license fee? The thing you have to notice is that if the amount of the so-called license fee is linked to the sales, that suggests to you that it is ad valorem. It is based on the value of sales. So therefore, if it's based on the value of sales, it is directly connected to the sale of a good. Therefore, if the exaction is connected to the sale of a good, by definition, it becomes an excise. And if it is an excise, what happens?
Well, it would be unconstitutional because they'd be invading federal area of.
Yes, because in that case, it would violate Section 90 of the Australian Commonwealth Constitution, because only the Commonwealth Parliament can pass excise. It's a clear prohibition under Section 90. So are we clear? So it's a flag. It's a signal to you that if it's ad valorem, it's based on the value of a product or value of sales, it is a tax on goods. And because it is a tax on goods, that is the definition of an excise. It is a tax on goods. Now, there was an interesting point earlier made by Robert, though, that what if the license fee is not based on the sale of goods, but it's assessed according to the distribution or marketing? So in other words, $10,000, there is an amount of $10,000 which is assessed as a license fee for the act of a business in distributing or marketing a product, for the cost of their service, of their distribution services and the cost of their marketing services. Robert says something about that. Does that make a difference? So if there is a license fee on the service itself, what happens then? Does that make a difference? Comment? So there is a license fee on service. So the answer is, if the license fee is on a service, that is permissible because that is not an excise. An excise is a compulsory exaction or a levy on the sale of goods. But if it is a sale of services, that is not an excise and is within the power of state parliaments to pass. Okay, now final question, just a bit of a change. I understand it's 7 o'clock, but before we go, just one final change of the facts. Let's assume this time that the so-called license fee of 5% of the annual sales is based on the annual sales, not of the current year, but of the previous year. So let's assume that the license fee is still 0.5% of the annual sales, but it is the annual sales of the previous year and not of the current year. Does it make a difference in terms of determining the constitutionality of this law passed by the Queensland Parliament?
I think that's the fact that he raised in Dennis Hotels, because that was the one where it was based on the previous year, and the court held that a proximity would determine whether it is an excise or it is not. So, for example, there's another one where the regulatory said that if it is based on the current period of the license, then it would be an excise. If it based on previous, it's not. So there was one act which says the license was excise, but the temporary license was an excise, but the license wasn't an excise because it was placed in a previous year.
Well, what was the reason for that, Bikia? Why would it not be an excise if it's still ad valorem, but the levy is actually based on the annual sales of the previous year? Why wouldn't that be a tax? Or why wouldn't that be an excise?
The court held that in Dennis Hotels that it was disconnected from the change of activity as not being a step in the process between bringing the item into being and until it reaches the consumer.
And so what in a nutshell, what does it mean?
It means that the amount that is based on, it's not in the current year. It is not somewhere in the step between where the stuff is produced until it reaches the final consumer. It's not along this step.
So what does it mean?
Well, then it then means it is not an excise because it's not based on the period during which the license runs.
So that's right. So what essentially the court is saying is that it's no longer based on the sale of a good. You can't really say that it's based on the sale of a good because that happened in the previous year. So remember the classic definition of an excise, it is a tax on the sale of goods. So if you're putting the exaction on the basis of previous sales of last year, how can you say that it's based on a sale of good? That's already passed. And because it is passed, according to the case of Dennis Hotels, it is not an excise. So be wary of that distinction. Because in that case, if you base the exaction on past sales, it can no longer say that it is an exaction on the basis of a sale of goods. Because the sale has been done. Okay, but if it were based on the current year, then you can quickly say, you can actually draw a connection between the exaction and the sales. But if it was based on past year, you can't say that the exaction is connected to the sale of the good because the sale has already happened. So it's, in a sense, it's remote. So make that connection. Yes, Robert.
Sorry. So all the previous year's sales were in fact the sales of goods. What they're taxing now is your income, not the actual transaction.
So if the exaction is based on current sales or on current transactions and is ad valorem, that would be an excise. But if the exaction corresponds to previous sales, it's difficult to say that the exaction is actually on the basis of the sale of the good, because that is already passed. So the court is making that distinction. So it's no longer, therefore, in a sense, solely on the basis of the value of the goods, because it has been passed. In a sense, it still is, because it's kind of ad valorem, but the High Court is saying that because of its retrospectivity, then there is no, as pointed out by Hiket, there is no connection between the fees and the sale. So in that case, because it is retrospective, it's no longer an excise. Oh, so in other words, Ken, if the exaction is retrospective in the sense that it's based on past sales, it is no longer an excise but a license fee. Yes, but again, it still does not. There is still an argument that could be made that if it is excessive, in other words, it exceeds the cost of running the regulatory environment, even if it may be argued that it is not excise in that sense, it could still be an excise if it is considered to be excessive to the value of operating the regulatory scheme or to the benefit that businesses will have as a result of running that regulatory scheme. Yes, B.
What about the other part which says that they only had to pay, you only have to pay $10,000, the flat part of the scheme?
You're talking about the actual question now, or the the new example I gave? I lost you. You're not saying, you've muted yourself, I think.
What about the part where it says after a certain amount, it is only $10,000, no matter how much more that is?
Okay, what do you think? So if there's a limit, what does it mean? It can't be an excise?
No, I don't know. I don't know. Can it be an
It shouldn't matter. For as long as it is a tax on goods, regardless of the value of the tax, it can be a very minimal amount. For as long as it is a compulsory exaction, regardless of the value of the amount, regardless of the value of the tax, if it in fact is a tax on goods, then it is an excise. Okay? And the only question, therefore, that we have is, for it to be considered to be legitimately a license fee, the other question we really have to ask is, what is the cost of implementing this scheme? If the license fee is excessive, then necessarily we know it is a tax. It might not even be an excise. It would still be a tax. So there are two aspects to it. It could be a tax, it could be an excise. But the thing is, if therefore it exceeds the cost of the regulatory scheme, it is likely to be a tax, and therefore because it is a tax, it is likely to be an excise tax. And in that case, that would be prohibited by the Constitution. Okay, it's 7:09. Any questions before we go? None? Okay. So thank you very much again, everyone. And it's actually week 9 now. It's going to be week 10. We're close to finishing the term, so good on you. Okay, so I'll see you again next week. Bye.